Thank you very much once again, and I'd like to see if we can do some house cleaning, so to speak, so that we can deal with some of the issues that you may say, well, they are major, but the discussion about the economy ought to be the most important thing to discuss. So if we can deal briefly with the issues of maybe the questions of the call for Barton Odro to resign or be sacked, and then also look briefly at Eric Amoateng and his problems. Then by the time all the other panelists are seated, we can look comprehensively at the questions of the IMF and the MCA compact that we have received. Now, Kweku, what is your response to those who say that the Deputy Speaker of Parliament should resign honorably for his comments to the effect that the state had a bad case from the start? It's not the first time he's making that assertion, and he's so convinced about it, he says if you ask him, is it 100 or 1,000 times, he will repeat the same, that the state had a bad case, and so what's it? Will it hurt what the state is trying to do now in the commercial court and also in the financial crimes court? Is that what you think?
Well, I'm going to be very brutally frank, he ought not to have been in Parliament in the first place if the electorate of, is it Cape Coast North or South, that has slipped me momentarily, had decided to look at the issues in a very clear-cut manner. He should have been punished electorally. He's not the only one. There are a few others like that. Two, the legislature ought to have exercised a certain level of circumspection in making him the first deputy speaker. So there too, I think there was a failure. So he was two-time lucky, in a sense. And so there's a fait accompli here. Whether we like it or not, he's first deputy speaker of Parliament. If he misconducts himself relative to standing orders and other laws of the land, there are procedures to adopt. There are things to activate. I'm not too sure yet that based on the statement he made, one can proceed to activate standing orders and other aspects of the legal regime to tackle his status as the first deputy speaker. So we may be talking, and this is my own personal opinion, we may be talking about perhaps a voluntary exit from certain positions, which happens in other jurisdictions, out of your own conscience and moral, principles. So that's the way I see it. So having the issue of whether he should resign or not, I think is more of a voluntary thing. If he is minded.
So is it your view that those statements amount to misconduct?
Relative to standing orders, I'm not sure. So that you could drag him before committee of privileges to tackle it, I'm not sure. It may end up being an exercise in futility. And I'm being very candid about the issues based on the factors that will have to be assembled in order to be able to deal with the issue appropriately. And that's why I said that within the realm of the legal regime and what you think he may have done to affect the legal regime, it may be very difficult to use the instruments of state or legislature to tackle him and exit him. That's my own view.
You don't agree that someone would say that what are you talking about? Lawyers would always have divergent opinions or views, professional views, advice to give on one matter. So if his professional view of the matter, from the way he sees it, is that government had no case, why should he be penalized for that?
Yeah, but that reinforces the point I am making. Exactly, man. It reinforces the point I am making. That so if you are talking of sack him, then there's a problem there relative to just what you have said. And that's exactly where my drift was. So I think maybe you didn't get me well. But I'm saying that from a purely moral, political point of view, he is not somebody that inspires confidence, and in terms of the principles of, morality and, integrity and credibility.
Well, obviously,
when it comes to
the verdict as his constituents gave him does not vindicate what you just said.
No, so I began by saying that the electorate should have punished him. That's what I began by saying. That elsewhere, in some constituencies, it's like the former GIPC boss. He wasn't punished. I'm not challenging the electorate's decision. That's
right.
their will. But I am saying that if we had a situation where political consciousness was so high and sometimes very critical, that takes into consideration certain issues, some of these gentlemen will not be in the House. And it cuts across the political divide anyway. We are now looking at a particular personality who happens to belong to a particular political party. So that's what is happening. But I'm not at this moment reducing it to just a political party. I'm looking at the gentleman and within the context of him being a member of the legislature, where you expect people to have a certain high level of integrity, credibility, and good political track record. I'm saying he was left unpunished, unfortunately for me, by the electorate, and also more or less compensated by the legislature by giving him the high status that he holds today within the legislature. Having said this, I was thinking that he himself would have done a lot of justice to himself, to his integrity, which already is on the wane, by shutting his mouth relative to the Woyome issue. He's explained himself. I've listened to the tape very carefully. It is obvious that he was talking about the particular judgment that Woyome had procured.
Default judgment.
Default judgment that Woyome had procured in court, and was looking at it.
Which led to the negotiation by the Attorney General's Department to now bring the amount of money down to what ought to have been paid.
But the truth of the matter is that before Woyome went to court, there had been negotiations between them, and they had not gone along with that terms. They had delayed or defaulted, quote unquote, and that's why he went to court,
right,
and got the default judgment.
Right.
Okay. Now it's very important that I explain myself.
No, but just hold on.
Okay.
We'll get a bit into the detail.
Okay. Okay.
Let me hear what Fifi Kote has to say about this. You are in Parliament. Now, there are those who are mounting a certain crusade that Parliament ought to begin to look at an option in dealing with its deputy speaker. The Progressive People's Party has issued a statement. There are others that have also called on Parliament to look for at least a parliamentary inquiry into his comments.
I'm actually, I wouldn't say I'm completely apprised of all the facts of this issue. What I can, however, say is that if it is that he's making a statement in 2014, no more in the position of a Deputy Attorney General, but making a statement now as a Member of Parliament and also as a First Deputy Speaker of Parliament. The most I can say that there is a case for he having right to his opinion. And the good thing is that that opinion at the moment really is not the opinion of the Attorney General. It's not the opinion of the government of the day. And as a Member of Parliament, we understand that Parliament is actually separate from the executive. I will grant him the right to having his own opinion on the matter. The moral dimension of it, I'm not sure I'm in a position to enter into the morality of that particular issue.
But he's a member of government, and government ought to be concerned when you say that his position does not reflect the position of government, because government position is what we have in court presently, that Mr. Woyome got the money by fraudulent misrepresentation, and that he had no contract. The Supreme Court has twice vindicated that position of the state through Martin Amidu's, fights.
When you say he's a member of government, and I want to understand what you mean exactly by that.
Okay,
are you saying that he's a member of the executive?
He's a member of the governing party.
Yeah, but members of the governing party can disagree with the government.
His position in parliament,
he can still disagree. He's a member
requires certain cabinet push, isn't it?
No, I mean he can disagree. I mean we've had precedents of members of the party, whether they are in parliament or otherwise, disagreeing. In fact, there are even members who are in government who still can disagree. So, in that respect, to be honest, I grant him the right to express his opinion on the issue. To the extent that that opinion does not represent the government of the day, to be honest, I'm fair about that. I think we should grant him the right.
Okay. I mentioned earlier that we have two legs of this same case pending in court. We have one, the criminal one, pending in the financial crimes court. We have one also which is instituted by the state. We have another one also instituted by the Attorney General's Department, which is also pending at the commercial court. These comments, won't they hurt government's position? Because government says, you have no contract, we don't owe you. Now
are you saying the comment by the first deputy speaker, who is not a member of the government, will hurt the executive? Is that what you're saying?
Will hurt the cases that are pending in court in a manner that will may disadvantage the state.
Anyway, I guess maybe people far more informed on this issue than me, possibly people within the Attorney General's Department, will be in a much better position to articulate so. But talking about making pronouncement on cases really that government is taking up against.
So let me quickly introduce, we have been joined by Sam George, who is a member of government's communication team. Welcome to the show. And also Nana Akomia, who is the immediate past communications director of the New Patriotic Party. Nana, welcome to the show.
Yes.
You're in red.
Yes.
It's a red Saturday again,
It
like
is.
the last time?
It is.
Okay. Now, if you go on.
Yeah, so the point I'm making is talking about having opinions, especially people within the Attorney General Department having opinion. My understanding, stand to be corrected, was that I hear Honorable Gatti, when he was Attorney General, also preferred an opinion to the effect that Isofeton did not have a case against the states. I thought I heard while he was Attorney General. What do you say?
Publicly on radio?
No, it doesn't need to come publicly. If you prefer opinion within government circles, those opinions actually can be rooted through different means. It can be expressed in cabinet, it can be written in memos to various sector ministers and so on. As I said, that's my understanding. And a Sofeton case proved to be otherwise than what he said then. So the point I'm making is it does happen sometimes that even people within government can have different and varying opinion on different issues. I suspect at the time other sector ministers thought otherwise, the Attorney General thought otherwise. So it does happen, honestly.
I see. Now, I'll have your take on this, Nana, but I just want to quickly refer to the judgments that was delivered by the 11-member review panel of the Supreme Court that was delivered on the 29th of July 2014. There's a portion, and I'll just quote what the court had to say. It says that, I'll just leave certain portions and come. It says, in the view of the immense responsibilities that are cast on the office of the first responder, that's the Attorney General, it will indeed be a travesty of justice to say that negligence on her part in failing to decide on a constitutional requirement which has led to a breach of the Constitution 1992, which only this court has jurisdiction to decide, is a matter for another forum, possibly the High Court. Now, the court wraps that up by saying that we think we fell into error in that decision and we must redeem the image of the court by correcting it. This will not only bring dignity and honor to this court, but also ensure that the justice which the good people of Ghana deserve is given them by people who are appointed to very high, sensitive, delicate, and above all, constitutionally created offices. Since these office holders are public officers. They must be held accountable for any lapses in the performance of their constitutionally mandated duties. Nana, it's the second time the Supreme Court has been emphatic, doesn't mince words, in pronouncing Woyome as a man who did not have a contract with the state. What do you say about the calls on the Attorney General and his comments? And I read this also to guide you having the benefit of the thinking of the courts, that state officers who are doing their duties, when they are found to be negligent or have failed to do the duties in the interest of the state, ought to suffer some consequences.
Thank you, Samson, and let me wish you, listeners and my co-panelists, a good morning. I don't think there's any debate about some people call it recklessness, but I believe that it's deliberate collusion. There's no debate about the deliberation that attended upon the payment of those monies to Mr. Woyome and other people and other companies. There's no doubt in my mind at all that there was collusion. That it can't happen the way the payments were done. You look at the sequence of events. Those payments will not happen if there was no deliberate decision to take money from the taxpayer. Indeed, one Supreme Court justice himself, out of total shock and misunderstanding, said that this can only happen when there is a clear intent to create loot and share. And the various judgments of the courts have confirmed this. So any state official who participated in this loss of money obviously was part of a collusion. So obviously was part of a collusion. It can't be people just being reckless or irresponsible. The way the payments were done, it is clear collusion. Any state official involved has fallen foul of the laws of Ghana, the financial laws and so on. And punishment, or at least the government making the effort to punish, is the least that we expect from the government. Because the courts themselves have ruled that these payments were not done properly. So if officials have been involved in processing, in signing releases and so on for these payments to be made, those officials must be guilty of infringing on one law or the other. Now, at this late stage, for you to have the former Deputy Attorney General, who was Deputy Attorney General at the time that these payments were being made, for him to still be telling us that those payments are legitimate is such a slap in the face of the people of this country. I can't imagine.
Kweku is giving a context, and I want to find out if you don't appreciate that context. And the context is that Woyome had gone to courts and obtained a default judgment. Simply put, he went to court, the Attorney General, obviously not having a defense, didn't go to court, didn't show up. So the court granted him what he requested. So he went seeking to enforce that judgment for the state to pay. So on that basis, his comments are to the effect that they had no case. They just had to go ahead and pay.
They had no case because there was a default judgment. But the default judgment was obtained because his office, what's his name? The Deputy Attorney General's office did not put up a defense.
Because at the time, they have also stated earlier that they were under a mistaken belief. They were under the belief that they had no defense anyway.
But if you were assuming that that was the belief in which you were under in the early parts of 2010, we're talking of the middle of 2014. You are still under that mistaken belief? Samson, it's just, you can't understand it. If you are mistaken.
State, or you're talking about Barton?
Sorry?
Who are you talking about? Are you talking about the state or Barton Odro? Who are you talking about exactly? When you say you are still under a mistaken belief?
We're talking about Mr. Barton.
Okay, just want to.
I'm saying that if you were under the mistaken belief in the early part of 2010, your own office subsequently went to court to try and get the money back. That's what your office did. And as we speak, your office, the Attorney General's office, representing the government, is still in court at the High Court, trying to get the money back. How can you still be making these statements in the middle of 2014, 4 years or more after? It's unbelievable.
And so you agree to the calls that he should resign?
Well, I believe that prosecutions should take place. As for resignations, those are individual decisions. But I believe that prosecutions should take place because clearly the financial laws have been violated.
I see. Very interesting. Now, Sam George, I don't know how you look at this issue. The ordinary bench of the Supreme Court on the 14th of June 2013 suggested that at least one of the judges came to the conclusion that this appears to have been an enterprise created, an enterprise established to create, loot, and share. This 11-member panel in the review application says the payment was done under bizarre circumstances and that the situations should provoke the conscience of the judges to do justice to the case, and that is what they did. When you cast that against what Barton Odro is saying, what do you say?
Well, let me say good morning to our viewers and our listeners and to my co-panelists and to your very good self, Samson. I believe that the learned judges of the Supreme Court of Ghana have expressed a legal opinion which we are all bound to respect as the final court of adjudicature in this country. However, the point must be made that the judges themselves are distinguished lawyers. And that's how come they sit on the bench over there. And we are bound to respect the rulings of the Supreme Court, especially when it's a review that is final. You know, within the jurisdiction of Ghana, that is final. However, as you know, as a practicing lawyer, there is no one case where you would have unanimity of decisions or opinions from varying legal personalities on the matter. You would always find somebody who can always play the devil's advocate, who can always have a different legal opinion, and he would ground it in law. So at the end of the day, it is not strange to find another established lawyer, because Mr. Barton Odro, if he had chosen, after his years of service, to even start from the lower courts, could most likely by now be sitting on the Court of Appeals or something, with a number of years as being a lawyer. So at the end of the day, if he also expresses his legal opinion and backs it in law, you cannot necessarily fault him. And I've heard people say that he must be made to resign. And I ask myself, it looks like when we sit in this country, we have different yardsticks and different measurements or measuring sticks for different individuals. I remember citing a document dated the 4th of June 2008, signed by the then Attorney General, Mr. Jogati, who today is now second Deputy Speaker of the Parliament of Ghana. That letter was written to the Office of the President and copied to the Chief of Staff. He expressed his legal opinion as Attorney General in the Isophoton case, where he said that, in his opinion, Isophoton had a case and the government was to be minded to engage Isophoton to prevent them from going to court. In fact, it was on the basis of that letter he wrote to the Office of the President that Mr. Jogati, or Honorable Jogati, then Attorney General and now second Deputy Speaker of Parliament, chose not to put in a defense that occasioned Isophoton's default judgment against the state. Fast forward to this year, you realize that the Ghanaian courts again, have stated clearly that there was an erring in that legal opinion, or they view that the Attorney General's position was an erroneous one. Nobody has appeared. In fact, the calls have been on government to retrieve the isophoton money. Nobody has called on Mr. Jogate to resign. You have another, in this case, not even an attorney general. He was a deputy attorney general who also expresses his legal opinion on the matter. Okay, in fact, not even in writing, but I think on an interview on a sister platform, this of multimedia, and expresses his legal opinion. And today, on the basis of that, he's being told to resign. I think that the standards by which we measure public officers must be one and the same. I hold the opinion.
Who asked the question? That it is not the case as you compare. Joe Gate, granted, that's what transpired. Have you heard him after the judgment of the Supreme Court insist that his position ought to have been what it should be? And that in any case, even if he has such views, you should be making them publicly, especially at a time when the state itself is back in court pursuing what it thought earlier was not the case.
Possibly it's a matter of convention and a matter of opportunity. Maybe Mr. Jogate never got the opportunity to be asked again his position on the isophoton matter by a radio station post the isophoton case. And more so, we should bear in mind that irrespective of where Mr. Barton Odro sits today as a member of parliament and sitting in the leadership of the legislature, he has the fundamental freedom of expression, freedom of speech. Okay, nobody can seem to gag him. It now comes to a matter of circumspection, and that's a personal matter. And I think that it does not fall within the jurisdiction of any of us to want to pontificate or adjudicate what the boundaries of his personal freedoms are. At the end of the day, if his statements infringe or fall foul of the laws of this country, the requisite state agencies can take action.
Do you think do you think they do? They infringe on the laws of this country?
Absolutely not.
You're a student of the law, right?
Sure.
Good. When it comes to the questions of contempt,
yeah,
simply means that you ought not to be heard to make prejudicial or biased statements or comments on a matter that is pending in a court of law. As far as we know, this matter is still pending in the criminal court and pending in the commercial court.
He made comments.
Is it in contempt of the court?
He made comments not relating to the pending cases in the criminal and commercial courts. He made comments relating to the judgment, the review judgment of the Supreme Court. That's a completed case. And even with that,
it's actually not in respect of the review judgment, because he made a comment before the review judgment was delivered.
Oh, I thought it was made after.
A day before.
A day before.
A day before.
On the morning of the review.
On the morning of the day? Yeah. Okay. So it's not as if his comment was directly at the review judgment. But I say that does not matter, because the substantive judgment, original judgment, was delivered in 2013 of June.
Sure. You see, for me, and here again, like you say, I'm still a student of the law. But what I think is that, or what my position on this matter is, so long as he has not faulted the judgment of the judges, he's only gone ahead to forcefully state his opinion. Okay, I do not believe that forms the basis for a charge of contempt. So long as you state because after the Supreme Court's verdict in the election petition, we had senior counsels in this country go on air and state why they disagreed.
You're talking about after the judgment. The court becomes what you say functus official.
Sure.
The matter is out of their hand. It is in the public domain, and you can make comments about it. But I'm asking about making the comments whilst the cases are still pending.
In the course of the case pending, the election petition, we had people sit even on this panel.
And we had people punished.
Oh yes, people punished for making contemptuous statements. But we also had people make comments about the ongoing proceedings and what their projections of what the eventual outcome will be. But then they always stayed within the boundary where they didn't cross that line. So you see, the point is, it wasn't only those who were called before the court for contempt that made comments on the case whilst it was ongoing. People made inferences. People drew where they thought the case was going to end. Those who said the president was going to remain in office, and those who said that there was going to be an annulment of the election. People drew their legal conclusions from it. Okay. It wasn't contemptuous, and I think that in this case, I think that we're just stretching a matter that shouldn't really.
There's a lawyer who sends me a text who says that the former Deputy Attorney General was in clear contempt of the court by his comments. And I was making a certain reference to part of the judgment, but because I didn't read, maybe you may not think it was directly from the judgment. They said that indeed the facts and bizarre circumstances of this case are enough to provoke our conscience in ensuring that justice is done to the good people of this country. Kweku, finally, wrap up on us on this for us.
I think that we must clear the cloud. There's some attempt to generate a certain unnecessary cloud over this. Where is the Joe Gatti thing coming from? That he wrote a memo dated June 4th, 2008 to the president as well as the Minister of Finance, indicating that he thought the government had no case and that the Asofotun guys had a case. That's a memo that was not subject to any public disclosure. Subsequently, Asofotun went to court, got a default judgment. Joe Gatti, as Attorney General, went to the court to set aside that default judgment because government disagreed with the opinion that he had communicated.
Correct. His problem was that government had disagreed with him as an Attorney General.
So the June 4th, 2008 letter had become moot. So of no relevance to even the discussion we are having today. Because when the court gave default judgment, the Attorney General went to court, the same Joe Gatti went to court to try and set aside that default judgment, which in fact the processes they end before the elections took place. This was in November, December 2008.
And Marietta Appeal-Pong successfully did that when she took over?
No, don't forget, Betty was there, and they went to court and drew the case for out-of-court settlement, which then came up with all these other matters. Okay, and indeed it was Barton Odro who was in charge of the Asofotun case. It was the same Barton Odro who ignored the professional group advice that government had a case and that Asofotun had no case. And don't forget that the AG's office had commissioned the professional group to give them the advice. And before the professional group could bring their report, the AG went behind them and had a settlement with the Asofotun, with Martin Amidu writing letters to his deputy then, Barton, and challenging the conduct. But this is not relevant to the issue we are discussing at this point. Right. We only show a certain trait. But you see, the point I was making is this. Barton was what you made the subject here. His statement on Radio Central, that as far as he's concerned, in spite of the benefit of hindsight, he would still insist that government had no case. And I have to be fair to him. He was relating, what he was saying was relative to that default judgment. So he was trying to say that technically, as a lawyer, that was his position. What surprised me most, rather, was the fact that with the benefit of hindsight, he was still insisting on that and saying that even if you asked him 100 times, that's what he would say. Now, my view is that if it is just that statement we are considering, how are you going to be able to ask Parliament to punish him? Because if you go to the standing orders of Parliament relative to contempt of Parliament, it will be very difficult to nail him on that. Now, a lawyer has told you that he might have committed contempt, but as we speak here, who is going to cite him for contempt? I'm not too sure it's a sustainable process.
Often in this particular case, then it would have been the state that would have cited him for contempt. But again, it's still available for any individual of this country to draw the attention of either court to
it is only when the court gets him, he gets into court and is found guilty, that we can decide to activate processes even within the legislature to suggest that his conduct might have led to the dignity of Parliament being undermined.
Okay.
So as we speak, I'm saying the option is that his own conscience is what should lead him to know that he's become a political liability, not only to his party, which is the ruling party, but to the legislature as well as the state of Ghana.
Okay. Thank you very much. And it's important also to note, as Kweku continues to bring us, factually, that Barton Odro's explanation is that what he's speaking about relates to the default judgment that Woyomi obtained from the court. Woyomi had sued the state on April 19, 2010, and he got a default judgment subsequently, and that's what Kweku is referring to. He got a default judgment on the 24th of May, 2010, which was subsequently settled by the Attorney General. There was a terms of settlement that was filed on June 4, 2010, and subsequently he was supposed to continue to receive his money. But you may be aware the Attorney General made a U-turn on the 9th of June 2010 and went to court to seek to set aside the terms of settlement that it had agreed to earlier, but that was not successful, and it filed a writ which is now pending in the court. If I can hear you just a minute each or so, and then we move on to the other matters. Yes, Sam George?
Yes.
Yep.
You see, I think that when my senior brother Kweku Baku wants us to basically ignore the importance of the Joe Gatti reference I made, okay, it's trying to blow away a certain cloud, which we need to consider, okay. At the end of the day, in this matter, this particular matter, because he basically says that Joe Gatti, irrespective of his opinion, still pursued the Isofuton case in court as Attorney General. Fair and square. Did he have a differing opinion? Yes, he did. Okay. Did he have to go to court because the president, who is head of government, says, I want you to go to court? Yes, he did. Yes, he did.
Advice from other lawyers. He's not the only lawyer in government. He wasn't.
Barton Odro expressed a different opinion
Consistently.
in this Woyomi matter. Is the state, has the state not, the state, because right now Barton Odro is no longer at the Attorney General's Department, but has the Attorney General's Department from the same party not gone to court to take action contrary to Barton Odro's position?
And you,
yes,
and you
it
think
has.
you insist that Barton Odro coming public with his comments does not hurt the state's case.
He's not Attorney General.
Joe Gatti has
absolutely
subsequently
not Attorney General.
defended
Okay, you see, he's not
why he went
at
to
the end
court
of the
to
day,
challenge the
no,
default
you
judgment.
see,
Joe
at the end of
Gatti.
the day,
Consistently.
you see, if the court or the state is going to take cognizance of every legal opinion that is shared by every practicing lawyer in this country, we'll hardly have any case code. See its logical conclusion.
No, you're talking about someone with a certain stature, not an
No.
ordinary person in the country.
At this point in time, there are a lot of senior lawyers. Did we not hear Mr. Samoku Jeto also give his own opinions on the election petition?
It's irrelevant.
Okay. After the election
he is
the
a
relevance?
senior person. No, Kweku, relax,
But we do that occasionally.
relax.
You will soon be doing it. You watch.
I won't do that.
The point is that you are allowed to disagree with the judgment.
Exactly.
That doesn't go in your favor.
Sure, you are allowed.
Okay,
and
thank
so
you.
I don't see why
Right.
this should form the basis for any calls for Barton Odro, except on a personal basis.
Correct.
He decides to do
that point
that.
you have made. Fifi, what do you say finally on this point?
Yeah, I think I explained my position earlier.
Right.
And it's simple. He's not speaking on behalf of the government. He's not the Attorney General. Neither is he the Deputy Attorney General.
Collateral damage.
His position as a member of Parliament is his position. But you know, if you ask me, I would rather have somebody who shows consistency and who stands by his conviction, regardless of what anybody says, than to have an Attorney General who clearly has disagreement, but who finds himself literally dragged to go and defend a case simply because the boss has ordered him to do so. If I were Attorney General in that position, I think I would have just resigned, because that clearly was not my view.
Okay.
So I would rather respect. I would rather respect. No, but the point I'm making is that
vindicated
no.
the U-turn he made.
The point I'm making
based
is
on
simple.
better advice.
The point I'm making is this: we need to understand that some people have their opinion, and to the extent that they can stand by those opinions, if truly that's what they believe,
Even when it is shown to be false.
Okay.
Thank you. That is your belief and your opinion. It's your opinion.
But that's why we are dying as a nation.
Legal opinions differ.
That's why we are suffering.
You can have five different lawyers,
but
and all of them
briefly-
will have 5 different opinions on a matter.
Right.
So really, it's just a matter of opinion.
Right, but Fifi, what do you say? When I read a portion of the review judgment where the court was very clear on the point that if people who are entrusted with authority take or give negligent advice or do not do their jobs well, they ought to suffer punishment. Even though the court doesn't say, and I asked that question, it doesn't say whether the punishment should be administrative or criminal. You have Nana Kumia saying there ought to be criminal prosecutions. When you hear the court say this, don't you feel that if that is the advice the Deputy Attorney General then gave, and which is found by the court to have been negligent advice, he ought to suffer some...
To be fair to him, he claims he had nothing to do with the Wayomi matter.
Right.
In the same interview.
It was not a brief that he was holding?
Yes, that his boss was dealing with it without his participation.
Okay.
Except that he eventually relied...
Yeah.
Can I add
okay.
this? That eventually he relied on a subordinate officer's memo to write a certain advice to the presidency. That's why he's claiming. I'm just bringing the facts out as they were.
Thank you very much, Kweku, for that. Nana?
Yeah, Samson, a little bit on the Joe Gatti angle. I mean, Joe Gatti, as Attorney General, had a position. Upon further interrogation of the matter, he reviewed his position. and
how convenient.
Please.
How so convenient.
Please.
How so
Because
convenient.
that is exactly what happened.
Please.
And then he proceeded, can I finish? He then proceeded to lead the government's efforts to defend the matter. That is a matter of record.
Convenience.
It's a fact.
But you see,
it's convenience.
But Fifi, you see, look at the subsequent events. The next set of attorney generals took the matter from court and started talking to ISOFOTON. They then appointed a group of lawyers to do due diligence and paid money to the group of lawyers. Before the group of lawyers could finish their work and bring their report to the Attorney General that appointed them, the Attorney General goes behind this group of lawyers and processes payments to ISOFOTON. This is the conduct on the face of the record. When the group of lawyers then brought their report, which suggested that no money should be paid, then they had a meeting that said that, oh, let's find a way out, and that let's blame it on some other people. This is the record as it is.
Now, you're a former member of Parliament. How can Parliament deal with this? Because there are some who are making the call, and the PPP's call is that Parliament should, take over this issue. How?
You see, I don't want to limit it to resignations and so on, because those are personal moral decisions.
No, you're talking about Parliament.
Yeah, I'm coming to it. I don't want to limit it to resignations, because those are personal decisions, moral decisions, and so on. Parliament may decide that the conduct of the Deputy Speaker has brought Parliament into some disrepute and may proceed. It's all nice and good. But for me, the criminal elements clearly established by the judgment of the court is what all of us should be interested in, not personal decisions as to whether resignation or not.
Thank you.
Now, let me, 2 seconds. The basis, Kweku Bakun talks about the basis of the comments made by the deputy speaker.
Right.
That basis is not any basis. Somebody comes to tell you that he's done work, he hasn't been paid. You don't ask him for a contract. You don't ask the people that he says he's done the work for. You enter into negotiation with him and agree to pay him money. And then there's some delay. Then he goes to court. You don't go and challenge him in court, and he obtains a default judgment. And you're saying that is the basis for you saying that we owe him money. That basis doesn't exist at all.
Thank you. And a Spike in Ohio in the United States of America says, Samson Barton Odro's comments are repugnant, repulsive, and cringe-worthy and nauseating. That man ought not be in Parliament. I think he should be charged for contempt for disrespecting the ruling of the Supreme Court. Simon in Walawale says, Samson, what gladdens my heart is the fact that the vilified Martin Amidu has been vindicated. Ibrahim Kopa in Tamale says the ruling on the Wayomi case is a presumption that issues of corruption under the NDC government are no more a perception but reality. So Barton Odro, who allegedly played a focal point in this Wayomi debacle, should rather do Ghanaians some good by resigning. Agble Mata Emmanuel says that, sends this from Ho and says, I hope by now, the Mahama-led administration has learned its lessons about the devastating effects of propaganda. Some judge should know that even though Barton Odro is a distinguished lawyer, he isn't yet a judge. Some should stop the propaganda of equalization. Thank you very much. Thank you very much for all of those comments. This show is brought to you by the kind sponsorship of Bank of Africa, as strong as a group and close as a partner. Star Travel Policy from Star Assurance. Star Assurance, that's your solid partner. MTN, welcome to the new world. ZipNet Internet, simply reliable, and that's your most affordable residential and reliable residential internet facility. Falcon Properties, they want you to own a property, own a small piece of the earth, be a landlord. That's what they want to say. We want to take a quick break at this point. We'll return, and I would require that we take not more than 5 minutes each or less, maybe 4 minutes each, to quickly deal with the question of Erica Mwating, and then move on to the questions of the economy, bread and butter issues. We'll be right back.